With that being said, I'll go ahead and introduce the speaker today. Just for, I guess, everyone and Mr. O'Donnell, I will mute the classroom after my introduction. So that way, don't feel bad about going to the front, grab food, just, still be respectful. And that way he won't get distracted by the classroom ambience. And we'll have a Q&A at the end if you have any questions for Mr. O'Donnell. But without further ado, this is Mr. Nicholas O'Donnell. He is a partner at Sullivan Worcester. He is the author of the Art Law Report, a prestigious art law blog. I have read some of the articles. He also has authored other pieces. He has argued in front of the Supreme Court, and he is co-chair of the Art, Culture, Heritage, and Property Law Committee of the International Bar Association. And funny story, this has nothing to do with his accolades, which are impressive. I met him through my undergrad professor, my fine arts professor, Professor Tiffany Silverman. And she hooked me up with him, and I'm thankful for her, and I'm thankful for him coming to speak to us today. So without further ado, I'll hand it over to Mr. O'Donnell.
Great. Well, thank you for having me, and it's nice to meet all of you virtually. Sorry I can't be in the room with you. I'm going to talk a little bit about my experience and how I got to this route, and hopefully that will resonate with some of you, or you may see some parallels in your own interest. And then I really would love to leave a healthy amount of time for questions. I can talk about myself all day, but that's less interesting, hopefully, than whatever's on your mind with whatever topics are of interest to you. The place where Addison started, I think, is apt, because when I met Professor Silverman, she was getting a graduate degree at my undergraduate institution, and where we were both studying art history. She was getting a master's, I was getting a bachelor's, before she wanted to do her graduate work. I don't remember where, but somewhere else, and to get a PhD. But anyways, that was how I got into this sort of business in a very roundabout way. I really enjoyed studying art history as an undergraduate in a way that I didn't expect, because it was not kind of a subjective, whatever you think discipline. And famously, the story I tell is the first paper I ever wrote in art history, I got a very, very bad grade because I wrote a paper like that where I declared what this sculpture meant and what it looked like and what this person was feeling. And my teacher said, "You don't know any of that. This is a wooden sculpture. It's 14 inches high. It's from Germany. You made the rest of that up." And so what I really liked about it was this intersection of visual analysis, historical analysis, economic analysis, and then really only then the interpretive kind of narrative part, which pulls in other really interesting aspects of literature and culture and mythology and iconography and all that. So I studied that as an undergraduate. I really, really loved it. I decided that I thought graduate school museum work was what I wanted to do. And I stayed in the town where I went to college in Massachusetts, because it had an independent art museum, which is actually, which overlaps and does a lot of work with the college, but which is its own institution. And I worked there for about 3 years, doing a variety of things related to their exhibition program. For any of you who haven't worked in museums, when you go see a show that's, Monet in the 1910s or something, right? And it's got paintings from all over the place. There's all kinds of nuts and bolts ways that exhibition comes into place. And one of them is this very kind of nuanced discussion where people will approach other institutions, directors and boards, and say, well, we're doing this show about Monet, you're doing this show about Van Gogh, and we have a Van Gogh, and we'd love to lend it to you, and you have a Monet, and we'd love to borrow that from you. And it's not quite quid pro quo, but it's and some of it is, and there's nothing wrong with that, but it's sort of a funny thing. And so, I would write a lot of those letters and just sort of be in the room for these conversations, and that was a lot of fun. We did a lot of other special projects because I was lucky to be at this museum at the time that it was expanding its programmatic reach dramatically from its historically sort of quiet focus on the collection it has, which is excellent. But they were really trying to expand the number of other things going on. They didn't have a big staff yet. to do it. So things like that included an oral history project about the couple that founded the museum, Sterling and Francine Clark, who were real characters. And probably most related to what I do now, this was in the mid to late 90s. And that's when a lot of the questions about Nazi-looted art were resurfacing and becoming newsworthy and front page news again. And one of the things that I was tasked to do while I was there was this research project into the museum's collection. One thing, for those of you who aren't familiar with the issue, that started happening in the 90s is because of a couple high profile cases, in particular, the Portrait of Wally case at the Museum of Modern Art, which was on loan from Austria, which the heirs of a woman named Leah Bondi came forward and said that was our aunt's, and she never really actually sold it. It was taken from her. This kicked off this understanding of this whole category of works that had changed hands involuntarily during the Nazi era under a variety of circumstances that just hadn't really been talked about in a very long time. And so one of the things that came out of this was the museum associations, who are fairly active in giving ethical guidelines and best practices and things like that, issued a task force recommendation about the goal of researching museums' collections for concerns about this issue specifically, publishing their findings, being transparent about the information they did possess, dealing with claimants or families, in a fair manner. This is a legal audience. The challenge that immediately became apparent, and I talk about this a lot in my book, is claims for paintings are claims to personal property, and personal tangible property claims are torts that are typically subject to 3-year statutes of limitations. So you see this painting in the back here, that's my wife's grandmother made that. Somebody steals that painting, I have 3 years from when that painting is stolen to sue that person, or 3 years in most states from when I discover who took it and where it is. And courts weren't terribly interested in fashioning a special rule just because of the historical circumstances of the Nazi era, which I'll get to all that in a minute. But anyways, that's sort of what I was doing at the Clark, and I really enjoyed it. And it was a really interesting combination, again, of this kind of historical, economic, what are the political events happening? What are the economic lenses that you view certain kinds of transactions through? Art is a thriving market. It is something that is bought and sold all the time on purpose. And so how do you judge a transaction in hindsight? Are you applying hindsight, or is there some principle that you can apply to decide whether that transaction is defensible? And then what do you do with all the years in between, all the transactions in between? The way these claims have often gone is things that were stolen or sold under duress, as we say, went into private hands of some sort or another, and often didn't surface in the market for a long time. But then sometimes they did, and then sometimes they went back into private hands. And so how you decide what to do with those histories when a painting comes back up for sale in the 90s or 2000s, or when it's been hanging on the wall of a museum since the 60s or 70s, when the first person who bought it after the war donated it. This is often the case. These are complicated questions. So I really enjoyed that work. And as you can see, sort of that got me thinking at the same time as the other work I was doing, that graduate work wasn't quite the right fit for me. I miss that stuff in a lot of ways. I really liked working in a museum. I really loved being part of exhibitions when they came together, and the scholarship, that went with them. But I didn't. I went to law school instead. And I didn't go to law school to become an art lawyer. When I was sitting in your seats, in law school, I wasn't really thinking anymore about these issues as much. I kind of figured I'd given it a shot, and that was satisfying, and I would do something else. So I've been a litigator for about 20 years here, same firm, and I love it. And I got into that when I was in law school, really through the advocacy competitions that my law school had. I really enjoyed those. Again, combining the reading, the writing, the competition, the advocacy, the thinking on your feet, the theatricality of it, to be honest, which is a lot of what litigation is, at least when you're in a courtroom, not hopefully being theatrical, but you know what I mean. Just the way you present yourself and carry yourself makes a difference. And I enjoy that, and still do. Most of my practice is still a variety of things unrelated to art. I do a lot of work related to closely held companies. I've done lots of financial services related litigation, particularly in the international realm over the years. Ironically, because of my art history studies, I spent a lot of time studying German, spent a lot of time in Germany, have, as a result, ended up working for a lot of German financial services institutions on securities and corporate disputes. That has, kind of reinforced and allowed me to be in the area for a lot of the other things that I work on now. So I, after about 8 or 9 years as a general litigator, decided that I couldn't quite leave this area alone. And I convinced the firm to organize the art museum law group that we have now, which is a lot of different things. It is some things that the firm had been doing for years before I got there, like tax and trust and estates and nonprofit charitable work, which are specialties that tax and trust and estates lawyers have. But of course, people own art collections. They often put them in trusts. They think about how they want to leave those collections to their children and heirs, or whether they want to leave them as gifts and what kind of gifts they want to make and when, those sorts of things. But most of what we've built out is related to litigation. And so within that, the kind of work I do, I divided into a few different categories. The biggest is the restitution related issues that I described. I wrote a book about this about 5 years ago. So these cases get reported on a lot, kind of one-off when they come up, when somebody makes a claim against a museum or something comes to auction and it becomes the subject of a claim. But for the first, decade or so after these claims started being litigated publicly, most of them ended in statute of limitations dismissals because the courts essentially said, with a couple exceptions, look, whether or not you told the statute of limitations from 1937 or 1940 or wherever, by this date in the modern era, you knew enough to make a claim, and that was more than 3 years ago. And even if you didn't, sometimes in a couple cases early on, courts would apply a laches defense saying, well, the statute of limitations might not have expired, but you knew that you had a timely claim and something else happened that prejudiced the current owner, like they sold it and you didn't object, or it's been on display for 20 years and you never said anything, and things like that. But most of those dismissals were on strict statute of limitations grounds. The other area of cases that came up, which is the kind of case that took me to the Supreme Court a couple of years ago, is claims against foreign defendants who have these paintings. So for your sort of brief overview, when the war ended and all this art was in the wrong place, the Nazis had looted outright hundreds of thousands of objects. Nazi functionaries and opportunists had stolen or sold under veiled or not so veiled threats from private individuals tens and hundreds of thousands of other objects. Things were all over the place where they weren't supposed to be because they had been taken. And so what the Allies decided to do, if you've ever heard of the Monuments Men, this was referring to the Monuments, Fine Arts, and Archives Division. And they went up through this, Herculean task of trying to send every one of these objects back to the country it had been stolen from. And for the most part, they did. They did not undertake to restitute works to individuals. They sort of said, okay, recipient country, you go ahead and take it the last mile. And, as you might guess, the results there varied quite a bit. The countries of Eastern Europe did almost nothing. Countries of Western Europe had, to varying degrees, kind of administrative claims procedures that victims and their heirs could pursue. But those were pretty time limited. So in a lot of cases, these claims procedures were wound down after 5 or 10 years. The Cold War had set in by that point, and governments were really hyper-focused on other issues. Suddenly cooperation with West Germany, was very different than it seemed like it might be in 1946. And so many thousands of objects ended up in the hands of the government where it had been sent back to. And so those governments, for the most part, just said, all right, well, we'll hang on to them. And they put them into various categories and held them in various ways. But sometimes they would just end up in state museums, either by accident, because there was a mistake in the paperwork, or for lack of a claimant. And so what happens, in the modern era, when somebody goes back and realizes, oh, this painting over here, that actually was my grandmother's. And this started in 2000 with the Altman case that you may have read about, the Woman in Gold case, when Maria Altman put together that one of the paintings that had been her uncle's and had hung in their home in Vienna and was taken from them by a Nazi goon, was on the walls of the National Gallery in Vienna at the Belvedere. But the Belvedere is a state museum. And if you sue somebody in Europe, first of all, you can't, at the law at the time, the law didn't permit those museums to give things back, even if they thought they should. And the way the court systems in Europe often work are, you have to put up a bond that's a reflection of the value of the claim. So if you want to sue somebody for a $200 million painting, you have to put up a $20 million bond, which is not practical for most people. So she sued here in the United States, invoking what's called the Foreign Sovereign Immunities Act, which is a very complicated body of law, but essentially in federal courts procedure and state court procedure, you cannot sue a sovereign entity under the principle of sovereign immunity unless there's some provision or concept of law that says you can. And until 1952, you could never sue a foreign country. You could never sue a foreign state. And then the State Department said essentially, well, there might be reasons you should. Sometimes governments are acting more like private actors, and in those circumstances, it's fair for them to be sued. So sometimes, and what would happen is, if someone sued a foreign country, the foreign country would go to the State Department and say, please tell the court that we ought to be immune from suit. And the State Department would issue what's called a suggestion of immunity, and then the case would be dismissed. Or if the State Department said, no, actually you sold widgets, you can be sued for this, then the case wouldn't be dismissed. It was very inconsistent and very ad hoc and very secretive, because it was just all backdoor diplomatic back scratching. And the claimant would just find out one day, oh, you're out of luck or you're in luck. So Congress in 1976 tried to remedy this by passing the FSIA to create a comprehensive scheme, setting the very limited circumstances in which you can sue a foreign state. And there are several. One is when the foreign state sues you in the first place. So if they come to U.S. court, they can't say, well, you can't counterclaim against me, I'm a foreign state, right? Makes sense. If they've waived it, they have the power to waive it. If they are acting like a commercial actor, things like that. And there's one called the expropriation exception, which says that if the claims concern rights and property taken in violation of international law, and the sovereign either uses that property in the United States, or you're suing an instrumentality, and the instrumentality is active in the United States commercially, then you can sue them. And so the district court in LA and the Ninth Circuit said, yes, this applies. This was a taking that violates international law. And the Belvedere sells catalogs and things like that. And here we go. That case went to the Supreme Court, but not on whether the law actually applied, but on whether it could be applied to those facts, but whether it could be applied to any set of facts prior to the enactment of the law, because these events, of course, were in the 30s. Law was passed in the 70s. Supreme Court said, yes, you can. This is about the status, present day justiciability or amenability to suit of the foreign state. So this is how you determine whether they can be sued. So go ahead. Now, the interesting thing about that case, and the lesson, at least in my view, unfortunately, that it taught everyone is Austria then agreed to binding arbitration. And Mrs. Altman won that case on the merits in arbitration. It's arbitration, no appeal, that's it. She got the paintings back. Since then, no foreign state has come close to amenability to that sort of thing. And they have resisted. So my suit against Germany, suits against Spain, Hungary, the Netherlands, have all, they've all resisted jurisdiction. Now, my case, which I can go on, I can answer questions about, we had asserted, and the DC Circuit agreed, the district court agreed initially, that because the Nazis' theft of art was part of its genocidal campaign, that violates the Genocide Convention. The Genocide Convention, for those of you not familiar, includes what you might think of as genocide, which is the elimination, right, the murder of a group of people for being a member of that group. But it also includes the attempted elimination of people, or the attempted elimination of their ability to exist, and that includes taking their property. So, of course, if you say, you group of people, I'm not going to actually shoot you, but I'm going to take away everything you own. So good luck, right? Even if you don't succeed in actually killing them, that is genocide, and that's very clear to the Genocide Convention. And we said, well, the Genocide Convention, it's a law law of the land since 1948. So this is among the violations of international law that Congress intended to address in the FSIA of 1976. And the Supreme Court said no, unfortunately. And what they said was, if the taking is from what's called a domestic taking, that the government is taking it from its own citizens, then it's not a violation of international law. This, of course, is wrong, because genocide is a violation of international law, and all genocide, nearly all genocide, involves the victimization of a government's own nationals. So it's a carve out that clearly was not justified in my view, but I'm not in the Supreme Court, so what do I know? That they then remanded to determine if the victims in our case were German nationals. Two of them had moved to Holland, and Jews as a group under Nazi policy were not considered German. So the district court didn't agree with that either and dismissed the case. We've appealed it. That appeal will be argued in the DC circuit next month, middle of next month. So those cases, as you can imagine, are very complicated. And I've handled other cases. I've negotiated claims against museums and private collectors in the United States. I've represented private collectors who bought something at auction and then later realized there was something in the provenance that might be an issue, and tried to work through settlements. I mean, the way this often happens, as I mentioned before, is if something comes for auction, the standards now are very different than they were 25, 30 years ago. Things that were sold 25 or 30 years ago without any questions, now if they come up, the major auction houses will not sell it until these questions are resolved. And so in the best case scenario, what happens in those instances is there's a resolution. Sometimes there isn't. Sometimes a lawsuit gets filed and then there's a resolution. Sometimes the lawsuit gets filed and somebody wins and somebody loses. So I've handled all kinds of those cases as well. The other big part of my art related practice is related to the more modern day art market. The art market has a lot of different sectors and components. It is not cursed with a great deal of transparency sometimes. I think this gets overstated often as sort of proof of wrongdoing. I think it's a little more complicated than that. But what I do, so and the result of that is that, speaking as a litigator, you get a lot of situations where two people thought they understood what the deal was, but they didn't write it down, or they wrote it down very poorly. Nobody called a lawyer because nobody wanted to call a lawyer, or nobody wanted to look like they were being uncool. And that may sound juvenile, but it really is that basic sometimes. People just sort of don't want to be the lame one who says, well, what if we wrote this down? And then somebody comes to me and says, well, I got this letter agreement and it says that New York law applies, but we have to have arbitration in Singapore, and we're all from Canada. What do we do? And it's just a mess, right? And so those things have to be sorted through. That kind of art law, I analogize it sometimes to sports law, which is to say there are recurring things like copyright law or UCC law that you need familiarity with, but it's often a set of contract or tort claims which are not themselves that novel, but they arise in a recurring way, and it helps to be familiar with the way that art markets work, whether auction houses work or private dealers or small galleries or things like that. And then so within that, there are some copyright issues. I wrote an amicus brief in the Warhol copyright case that's under advisement right now in the Supreme Court, which is a very interesting oral argument. If you haven't, I encourage you to listen to it. I think there's a lot of perspectives reflected in the argument, some better articulated than others, but I thought it was a very interesting oral argument, which is always, I think, a great training exercise, whether you're a law student or an experienced lawyer. Because if you're going to be a litigator, how judges think and the kind of questions they ask is what matters, because they're the judge. And it's a hard case. It's a hard case because what fair use ought to be and what value judgments you make about whose creation gets to be exploited or protected is something that the Copyright Act tries to balance. And depending who you ask, does balance. But there are a lot of what about this? What about this? Questions that are not, first of all, they're not political, right? So it's a nice case to listen to with some very, very smart Supreme Court justices really trying to probe the limits of various arguments coming out of a statutory interpretation. And it's fun. And it's a cool case. It's about Prince, who's awesome, and Warhol, and that kind of thing. And then the last thing I would say is just like, I said, I talked a little bit about nonprofit governance. a question of museums, administration, and governance, and their rights and responsibilities doesn't get litigated a ton, because usually those are questions for the board. And if there's a question about the board's performance, it's an attorney general who supervises that. But there are circumstances in which you can give a conditional gift that has a connection attached to it. And I would give you two examples. One, so I was involved in litigation. We were unsuccessful, but I brought a suit on behalf of some local residents and members of a museum called the Berkshire Museum in Western Massachusetts, which sold essentially its entire painting collection in one fell swoop because it was having financial difficulties, which is at odds with best practices of museum associations, not least of which is not only because it's sort of bad form. It's not really about that. It's about the idea that museums are stewards of art as a separate kind of property. It is not simply a balance sheet, and museums are not obliged to put art on their balance sheets. And the flip side of that is you can't kind of treat it as a piggy bank. The attorney general in that case in Massachusetts initially opposed the sale and ultimately decided that the museum had done enough to justify the sale. And then if you look, there was an article in the New York Times over the weekend. I'm not just saying this because I was quoted in it, but Valparaiso University in Indiana has some really beautiful paintings that it is proposing to sell to renovate some buildings on campus. And this is what brings this issue into focus. Again, this will probably be a question for the Indiana Attorney General and no one else to fight about, but it's an interesting question about legal principles, because these paintings came from a donor, his name was Percy Sloan, who put them into a trust, and the parameters of the trust were that the trustee was to look for a place to leave these paintings permanently. And the trust has a lot of very explicit language about why the donor or the settlor put these paintings into a trust. And it was for the education of students. It was so that they would be in a university setting that students could be exposed to them. And so one of the questions that's interesting in that case, I can't tell you what the answer is going to be, I know what I think, is whether the attorney general looks at that trust, which the gift to the museum, to the university 70 years ago, acknowledges and incorporates by reference, whether they were bound by those requirements. I think they probably were. That probably, whether that's enough for the settlor's heirs to enforce, I can't tell you under Indiana law. I'm not an Indiana lawyer, but these are the kinds of things that are very interesting. Courts are loath to fashion conditions where they are not explicit, or where the enforcement of those conditions isn't explicitly given to the donor's heirs. But this is going to be an interesting case, I think, because the sort of this is what the collection is for is very specific. I apologize for my dog. I don't know why he's barking. So these things are all really interesting, and they just sort of involve this overlap between the market, governance, history, and all the rest. It's a practice I find very interesting and fulfilling. Anyway, that just for your benefit, as you think about the kind of careers you want to have, has allowed me to work into my practice. As you can hear, a lot of the things that I find very interesting and that I really enjoyed before I was a lawyer. I think some of the best advice I ever got, and sort of the reason I came to this, by the way, as a young lawyer, was when you think about client development and what sort of work you want to do, the networks you build are a big part of that, and the networks you build are going to be the things you find interesting. If you don't like bankruptcy law, then going to bankruptcy law seminars is not going to be very interesting to you. But if you do find it interesting, you're going to love it. And so I got back into the art circuit, because I had this interest, and I thought, all right, there's all these legal interests and issues I keep reading about. Let's see if I can get back in touch and sort of get a little more versant in this. And I set about trying to make myself a little bit more of an expert on certain of these issues, and I wrote about them a lot. That, the blog that, as mentioned, is sort of how I think first got on most people's radar. Between 2010 and 2014, I wrote a lot of articles on that blog, probably 4 or 5 a month, and just really tried to plow through them. And in the process, got myself up to speed, not just on one-off stories, but a lot of these principles, and that kind of led to the book. And and everything else. So that's what I do. I'd be happy to talk. People have questions about anything they've read about that I've done, or anything they've heard about on any of these issues, or about developing your career, or things like that. I'd be more than interested.
All right, thank you. Before we dive into the Q&A, I forgot to mention at the beginning, big thank you to the Entertainment, Art, and Sports Law Society for co-sponsoring this. I think Natalie and Matthew are in Zoom. So does anyone have any questions in the audience? Yeah, James?
Yeah, what lengths are museums willing to go to kind of negotiate these claims that are made against pieces that they might have in their possession?
It results very widely, I would say. And I think the good news that I see, having represented both museums and collectors and claimants, is it's changed a lot. I think when people first started raising these claims 25, 30 years ago, the museum's response was often, what? That was a long time ago, wasn't it? And I think it is fairly accepted, with a few exceptions, that these are legitimate questions, and that a painting with a problematic provenance is something that no one should want, and that it's worth diving into. I think from there, it is often a question of resources. There are a number of museums, the Museum of Fine Arts here in Boston. I was down at Yale a couple of weeks ago, who has appointed a curator of provenance for the Yale University Art Gallery. The Nelson Atkins Museum in Kansas City, a wonderful museum, has a full-time provenance researcher, for example. That gives them the ability and the credibility when someone comes forward to really dive into it. So there was a claim against the MFA here that I write about in the book, where ultimately, sort of ironically, they won it on a statute of limitations defense, because the claimant's lawyer made a demand and then didn't do anything for more than 3 years. So all the other arguments about how much time had passed since the 30s didn't matter, because in the present day, clearly more than 3 years had passed since they were aware of the claim. The MFA could have won that case with a 5-page motion to dismiss, because 3 years had passed. But what they did was they sort of showed all the work they had done to go into archives to show that the collector, who lost a lot of property in Vienna, viewed a certain group of paintings one way, and his sons pursued them very vigorously, and that this and others more likely were among a group of things that he intended to sell, not because of the circumstances. And it's nice when you see that. It's nice when someone dives into it. And the fact is, the in-between ones are the hard ones. And I have settled cases with museums that I thought handled it really well, and it wasn't sort of a zero-sum approach of looks like something maybe not kosher happened here, but it's hard to tell for sure. We could really go to the mat and say, you got to prove it, or it's been too long, but we don't want to disparage this historical episode in that way. And so there's I'm giving you a very long-winded answer to your question, but there are a lot of different styles. I think overall, the quality of the conversation has increased, almost immeasurably, from even 15 or 20 years ago, certainly 25 or 30 years ago.
Any other questions? Because I might have one myself. Mr. O'Donnell, as someone who's interested in this field, if you're comfortable answering this question, what challenges would you say you face getting into this field of museum law, if you don't mind me asking?
Well, I think the biggest challenge is, I find it interesting. A lot of people find it interesting. There aren't always a lot of, paying cases to develop a practice, to be, blunt about it. And so just sort of finding the work to do as a practicing lawyer can be very inconsistent. And certainly, the advice I give people, and it sort of is, you never know how it's going to work out, but, the clients I've been fortunate enough to have hire me because they think I've got the litigation experience and skill to argue their cases effectively. My interest in the subject, my prior connections, is some of why I know those things substantively, but ultimately they're hiring me for my skill and training, right? And so whatever it is you want to do, your best bet is to become the very best and skilled lawyer in that discipline that you can be, whether it's tax, trust and estates, litigation, corporate work, whatever. And there are places for all kinds of lawyers in the art world and in art law. Most of the people I know who work at the major auction houses are transactional lawyers. That's not me. That's never going to be me, most likely. So I think, it's a combination of, as I'm sure you've been told a million times, just, keep doing your best, keep trying to get as good as you can, and just sort of keep your ear to the ground and be opportunistic for events, speaking opportunities, helping organize events, pro bono cases, pro bono work, no matter what you want to do, is a great way to get experience of the sort that it's harder to find until later in your career for paying clients who want their money to be entrusted to people with more experience than new lawyers. It's a, self-fulfilling prophecy. That's the eternal challenge of being a young lawyer, but it's the challenge that people meet every day.
Thank you. Does anyone else in the classroom or even on Zoom have a question for Mr. O'Donnell? No one on Zoom. I'm checking the chat. Well, Mr. O'Donnell, do you have anything else to add for us today?
No, like I said, I hope for those of you who find this interesting, I'm always leery of sounding too discouraging because it isn't an area. I mean, it is not all of what I do. Of the folks I know doing very sophisticated art-related legal work, very seldom is it their entire practice either. But whether it's art or sports or whatever it is, I think if you keep at it and try to find ways to work things into your practice that you enjoy, you'll have a great career, because it's, you will meet lots of lawyers who complain about being lawyers, and I encourage you not to listen to them. There's a lot of interesting things you can do in a law practice. A lot of things you do in a law practice that are not interesting, because guess what? It's a job, and jobs are not interesting every day of the week. But it is a profession that I think allows you to bring a lot of what you care about and find interesting. And I would encourage you in that regard.
Yes, sir. Thank you.
Well, and I really appreciate you having me. And I'm sorry I couldn't come down and be there in person. I haven't been to Charleston in a while, but someday soon, I hope.
A little bit cold and gloomy right now outside, so.
Well, we're supposed to get a foot of snow tomorrow, so we're not out of the woods yet.